Good morning and welcome to PV Legal's daily newsletter. Today's story is about patience, extraordinary, almost superhuman, bordering on saintly patience. Because today we bring you a Supreme Court judgment that was triggered by a show cause notice issued in the year 2001. Yes, 2001. The year we were worried about Y2K bugs, the Hindi blockbuster Lagan was competing for an Oscar, and your current smartphone had not even been imagined. That show cause notice has finally been decided in 2026. 25 years later, the case, Rashtriya Chemicals and Fertilizers Limited, or RCF, versus the Commissioner of Central Excise. Here's the story in plain English. RCF is a government fertilizer company. It buys Naphtha, a petroleum product, from HPCL at zero excise duty. Why zero? Because there's an exemption notification that says, Naphtha used for making fertilizer, no duty. Simple, clean, straightforward. Except the taxman said, not so fast. The naphtha, you see, was first burned in a boiler to make steam. That steam then went to turbo generators to make electricity. That electricity then went back to run the fertilizer plant. So the revenue's argument was, naphtha didn't go directly to fertilizer. It took a scenic route via electricity, therefore duty. RCF's response? We bought it to make fertilizer. We used it to make fertilizer. The fact that steam became electricity became fertilizer doesn't change the intention. And the Supreme Court agreed. It held that the exemption notification says intended for use, not exclusively and directly and without any intermediate step used. The word exclusively simply does not appear in the notification. The revenue, said the court, had been kind enough to insert a word that Parliament had deliberately left out. But wait, there's more. The revenue had also invoked the extended limitation period of 5 years, accusing RCF of suppression of a government PSU that files applications, gets CT2 certificates, discloses everything, and whose every rupee of additional duty would have been reimbursed by the Government of India anyway through subsidy. The Supreme Court called it what it was: revenue neutral, no benefit to RCF, no loss to the government, no suppression, no extended limitation. Case closed. 25 years, dozens of show cause notices, multiple adjudication rounds, the High Court, the Supreme Court. And the answer? The exemption was valid all along. As they say, justice delayed is justice delivered eventually. This has been your PV Legal Daily Newsletter. Stay informed, stay ahead. Good day, and thank you for watching PV Legal's Daily Newsletter.